with us Ms. Sakshi Vijay, who will be speaking on the topic of the relevance of the Mediation Bill. If I may request our Associate Dean, Ms. Varsha Vahini, to formally welcome the speaker. Varsha ma'am, over to you.
Thank you, Bharatendu, and I'm very happy that you are organizing this particular webinar, which is on very relevant topic, and particularly for students who are going to enter into the profession in next couple of months. May I take this opportunity to welcome Ms. Sakshi, who is going to deliver the expert, lecture on this particular topic of mediation bill. Before I hand over the podium to Ms. Sakshi, may I take the privilege to introduce Ms. Sakshi to the audience. Sakshi Vijay is a graduate of ILS Pune who did her masters in international dispute resolutions from University of Melbourne, Australia. Currently, ma'am is working in Jindal Global Law School as an associate professor. Before that, she has worked as consultant with Law Commission of India. Prior to working with Law Commission of India, Ms. Sakshi has worked as an in-house counsel in an oil and gas exploration company situated in Gujarat. Sakshi ma'am is also an accredited mediator and joint secretary of Madhyam, which is a council for conflict resolution. Ma'am is a trained mediator who took her training in Australia and then as a tribunal secretary in Hong Kong. She has also made representation at the Rajya Sabha before the Parliamentary Committee for Amendments to the Mediation Bill 2021. The bill is still pending, it has not yet become an act. And to be very honest, I am as clueless about this topic, about this bill, about this area as my audience could be. So I'm hoping that through this webinar, I'll also have some clarity as to what mediation is, what are its uses. So far, mediation as a tool or as an instrument of conflict resolution has been adopted by courts, but there has been, but no legislative framework has been there. So I feel that this topic is very pertinent, very important, and I hope to gain a lot of information and insight into mediation. Thank you very much, Sakshi ji, for joining in this webinar. Over to you.
Thank you so much. Thank you so much. Thank you, Ms. Varsha. Thank you for all the kind words, and I'm sure this exchange today I'm going to learn as much from everybody else here. And Bharatendu and I actually work together in the Law Commission of India. That's where we work, and we share our love for ADR, and our masters have been that. So I am actually very excited to have this opportunity to discuss with you all what I have been working around for at least the last 2 months ever since the bill was introduced. And one of the stakeholders of the mediation bill is the common man. And I'm perhaps representing the common man. I do not read this bill as a lawyer. I am reading this as a consumer, as a reader, and that is how today I'm going to discuss this with all of you. Thank you for giving me the background that you are all ADR students. I understand you're from a same class, like a batch, or are there other juniors and seniors as well? In that case, I'll just give you a brief background about ADR itself, and then we will go into the waters of what the mediation bill is. So I am going to, my slides don't say much, but it will just give me something to stay with you. Now, because we are all part of the law school, we know that our bread and butter, or a lot of things around law is starts with dispute resolution. What are disputes? How do we resolve them? Now, I can give you examples throughout. We can take examples from history. We can take examples from current
Excuse me,
affairs.
ma'am.
Yes.
Ma'am, what is arbitration? Oh, okay, sir. Okay, sir. Okay, sir.
Okay, so we will definitely get to the end of the. We'll open the floor towards the end, and once I tell you a little bit more about it. So in fact, we don't even need the slides. Whenever there's a dispute, and this happens, at least I have seen it a lot in our city in Delhi, where we are right now, is that people become very angry. There's a lot of rage, and the outcome or the last resort, the final warning is that I will see you in court, or I will sue you in court, as they say, right? So whenever you think of a dispute as a lawyer or even as a layman, you always think of the resolution or the determination, the end of that dispute to happen in court, right? This is what we have been taught when you told your parents, or when you decided to be lawyers. Probably what you imagined or what you had in mind was that you're going to resolve people's problems, or at least represent people's problems and go to court. So this is the image we have in our heads when we think about disputes, when we think about resolution of disputes, and we think about jobs of lawyers. Now, this is the mainstream. So, when you think about disputes and resolution of disputes, actually, the correct word would be adjudication of disputes, which is deciding who is right, who is wrong. The only image we have in mind is that of a judge sitting, a colonial image that has been framed in our mind. There are two parties, there are two lawyers, and they are fighting and trying to prove who's right, who's wrong. Now, at one point, perhaps this image was correct, but as and when the disputes kept growing, from 10 disputes a day that a judge has to be just to hear, now that the population has increased so much, that we just going to courts is not enough for us to resolve our disputes. That has become problematic. So what was an alternative that was found? What you have been studying, alternative dispute resolution, what this society is about, right? ADR. So the mainstream, remember, if there's ever a dispute, the first alternative, the first mainstream solution that you think of is going to court. But is there an alternative to that? Yes, there through there's a separate jurisprudence on how ADR came into being, but there were some drawbacks in the regular court system. One, there was a lot of time taken to adjudicate, to decide on disputes. There was a lot of cost involved, and more than that, a lot of times parties felt, say for example, Bharatendu and I are involved in a dispute that is around shipping. and it is a very, very complicated case with engineering, details of engineering and law, and there's a different substantive law, procedural law, and we feel that we're from different countries also. So there's a lot of variable factors involved, because of which we feel that an ordinary court judge sitting in, with all due respect to the judges sitting in civil courts in India, they might not be able to master, or even if they do, they might take a lot of time to understand the dispute and get the expertise from expert witnesses and then apply that to this case. So the solution thought for that was arbitration. Arbitration simply means that instead of going to the court and resolving or asking the court to decide who's right, who's wrong, you simply go to an expert instead of that. So it is a private adjudication. Adjudication here is an important term to understand. It means deciding who's right, who's wrong. So suppose in our dispute between Bharatendu versus Sakshi, we go to a court of law. The court of law will either say Bharatendu is correct or say Sakshi is correct, but the court is deciding who's right, who's wrong. This form of resolution of dispute, or rather, this form of treatment of a dispute is known as adjudication, where there's a third party which decides who's right and who's wrong. Accordingly, the decision may be that Bharatendu wants compensation, so I will have to pay that, or I will have to specifically perform the contract, etc. Whereas in arbitration, the same situation, there is still adjudication. It still means that somebody else is going to decide who's right, who's wrong. But here, that third party is not going to be a court of law, but a private person. Say, for example, Miss Vahini. Miss Varsha is an expert in maritime law and the engineering dispute that me and Bharatendu have. So instead of going to a regular court where we are unsure if the judge knows about our issue in such detail, we go to Miss Vahini because we feel that this is her area of expertise. Now, when we go to her, we are going to pay a fees to her as an arbitrator. She is going to be again a third party, a neutral party. She will not know Bharatendu or me. And she will decide like a court because she is deciding who's right, who's wrong. But here, instead of she being a court, she is a private person and we are paying her to do a service to us. And what is that service? That she is going to decide for us who's right, who's wrong. Now, there are complications relating to arbitration. Some say that execution, till today, there's no straitjacket formula for that because a private person can give a decision, but how can they execute a decision? Then there are problems about costs being equally or even higher in arbitration than in courts. Remember, here we don't get court premises, we don't get the court's expertise, we have to pay for everything, and sometimes time taken. I mean, India is still struggling with the time involved in arbitral proceedings. These are things you might have studied in arbitration, but remember, still we are just talking about somebody else deciding who's right, who's wrong. Now, when we think about a dispute, sometimes that is not the only solution to it, right? Remember, we're talking about resolution of a dispute. Now, sometimes if there's a dispute between Bharatendu and me, if we both are aware of all forms of dispute resolution, we might want to do something else, a conciliatory form of dispute resolution, which means that we are not going to go to court or a third party to ask them to decide who's right, who's wrong, but instead we are going to go to a mediator. Say, for example, I can see Mr. Vibhanshu Singhal here on the screen. So we may know Mr. Singhal to be a very good mediator. So we go to him. What do we do here? We both tell him our problems individually, why there is a dispute, our side of the story. And instead of him deciding who is right, who's wrong, he's only going to help us reach a decision, which means that maybe Bharatendu wants some extra delivery and I want some extra payment, but we are struggling how to reach to a mutually agreed agreement or a solution, and Vibhanshu will just help us steer closer to that. Now, this is an oversimplified version of telling you what a mediation is. Mediation can work in most disputes. Now, why are we talking about mediation? Or before talking about the relevance of the mediation bill, we must take a minute or 2 minutes to understand what is the relevance of mediation. Now we can break this down into different sectors. I will start with the commercial sector because that is hit the worst because of delay in courts. So you may have an idea about how much time it takes to get a stay order or an injunction under a contract. To be optimistic about it, also, I can tell you that you will need at least 6 months or 1 year to even start or even to reach an interim decision stage. Uh, Sometimes you don't want to go to court for unless it's an ego fight or something. And I'm quoting somebody else. I heard this in another conference that I was attending, and it was said that the business of business is to do business, right? It is not to go to court and resolve disputes. So if there are two parties who want to carry on with their business, they know that going to court is going to delay their business relationships. They are going to be adversaries, opposite parties. They're going to throw mud at each other in public places, right? So it becomes difficult to come back and do regular business. A lot of times it is said that it is the lawyers or third parties that nudge the two disputing parties towards adversarial resolution of dispute, which means deciding who's right, who's wrong. If my lawyer continues to tell me, no, you're right, why don't you fight this? You will feel the urge to do it. However, is it really beneficial for me? Am I not losing time, money, and business by going to court? Even if, say, I get rupees 1,000 or 10,000 less from Bharatendu, but won't I lose 6 months and pay fees to lawyers, etc., etc.? I mean, I can recover that through costs. But a lot of times, in pure commercial terms, it does not help. It is not beneficial to go to court. So, in these cases, and now even the government seems to understand it, you may be aware that India scored really low, embarrassingly low on the ease of doing business index. And the main reason for that was resolution of disputes to be extremely slow in India. So, after all of these indicators, the Indian government, the legislature, and the executive, and even the judiciary, I may add, has been very, very proactive in pushing mediation, especially in commercial disputes. And the reason is because we want people to do business in India and not be scared that if there is a dispute, we will have to go to court and it's going to take forever to resolve it. We want to create an image that dispute, and the definition is very wide, then even before they are heard in court, they will be attempted to be resolved through mediation. Now, when we read the mediation bill, we are going to distinguish between an attempt to mediation and compulsory mediation. So we're going to discuss that. What I'm trying to tell you now is the time has come for India to have its mediation movement, and we are at the brink of these exciting times, and that is why it's relevant as law students. As much as it is relevant to talk about CPC,
Hello.
CRPC, procedural laws in the mainstream adversarial system, or
All
say,
right,
for
sir. I'll
example, as
have to.
important it
I'll
is
make
to
you a
talk
co-host,
about
sir, in that case.
arbitration
And
for lawyers, for
just be
upcoming
online.
lawyers in India. It is equally
Please
important
be online.
to talk about mediations in India,
Let me
because
just
10
see
years from
how I
today,
can do
20
this.
years from today, we are not going to imagine ADR as an alternative means to resolve disputes, but actually an appropriate
हाँ हाँ
means
मैं
to
समझ गया सर.
resolve
Let me
disputes.
just
So
see
that is where we are standing now, and as law students, it is
participant
very
time
important to have this
present.
dialogue.
I
Not
can
just to
see
know
like your
textbook meaning, but also why do we
what do we
require it.
say?
To tell
When
you
I
actually
see I
honestly,
can see
and
your
Ms. Vahini actually highlighted that, but is there even a law that we study? And I mean, there is an Arbitration and Conciliation Act, and there's
remove नहीं
so
करना
many other
है,
acts we
pin
study,
नहीं करना
procedural
है.
and
तो
substantive, when
कैसे
we talk
करूँगा?
about the court system. But is
ये
there
इनको बनाया
anything
था
to
मैंने.
really study in mediation or
Yes.
in conciliatory forms of dispute resolution? So I'm just going to highlight one thing, and I'm taking you to the slides. So the mainstream is going to quote the alternative. Technically, is arbitration and
Okay.
mediation, but
Let me.
the
I have
difference here I'm
turned
going
it
to
on for everybody,
highlight,
so I
at
think
least
they
for the
should
purpose
give
of
you
this
access.
lecture, is not the mainstream
Please
form of
check.
dispute resolution versus
Lovely.
alternative, but adjudicatory versus
Is
conciliatory.
okay.
Adjudicatory here means a third party will decide. So in my example, Miss Vahini would decide whether I am right or Bharatendu is right. Whereas in conciliatory, me and Bharatendu will not focus on who's right or who's wrong, but what the solution is or how will we move forward and how will we resolve this dispute more than decide who's right, who's wrong. So the goal shifts. How is it decided? It is decided by the parties in an adjudicatory form. Who is right and who is wrong is decided by a third party judge. How is it decided? It is decided by taking into account the relevant laws. If, for example, there's a breach of contract, then the judge will see the facts and the laws, say the Indian Contract Act, and apply them to the factual situation, and that is how it will be decided. Whereas in a conciliatory form of dispute resolution, disputes are not really decided, but they are resolved. So we don't necessarily have to check with the Indian Contract Act who's right to find out who's right, who's wrong, but we have to check with the Indian Contract Act to decide to determine whether our solution or our resolution is legally possible or not. Who does it benefit? Now, the adjudicatory system, well, there is a whole a whole parallel legal system. The mainstream legal system is running on basis of that. It's the courts, it's the lawyers, it's everybody. But the question is, does the party who wanted a relief and perhaps will get it at the end of the tunnel in the adjudicatory system, but of course it is going to take time, and not just time, there is something called litigation fatigue, which means that when you start your fight in a court of law, there is a lot of enthusiasm, but so many dates, even in the best of courts in India, I feel circuit trial courts are very, very effective, but even in the best of courts in India, there is some sort of a fatigue that sets in after, say, about 6 months of filing a dispute, and you ask yourself, is it really worth it? You want to give up sometimes, right? So does it benefit the party who is actually in need of the relief? And who complies with it? Another very important question. Now, say, for example, in the example that we were using where Bharatendu and I were in a dispute and Miss Vahini was deciding. So, adjudicatory resolution was happening. She was either the court or an arbitrator who's going to say that I have to pay rupees 10 lakhs to Bharatendu. Now, who has to comply? I have to comply because else is telling me to do it. Now, a lot of times when somebody else says that you're wrong, or you have to do something, there is a rebellious sort of an attitude. Plus, we all know that it's tough to hear that you're wrong, right? Especially when you fought for being right for so long. So there is a tendency to judge the judge or question the judge. Maybe she made a mistake in deciding. And what does CPC provide us in this case? The CPC provides us with an appellate mechanism. So I then file an appeal against this decision where I was asked to pay rupees 10 lakhs. And this goes on till the Supreme Court or till wherever the litigation fatigue sets in. But what happens in conciliatory methods? Conciliatory methods, nobody tells me or Bharatendu what to do. We both sit together and we decide. Suppose I decide that I will pay rupees 5 lakh and Bharatendu says that he will change the material that he has delivered to me. Both of us make a little compromise, but because both of us have decided this on our own without somebody else telling us that we have to comply with it, the chances of actually complying with agreements made after mediation are much higher. It's like your attendance is not compulsory, but if you want to come, you can come. In that case, the chances of the people who have come to hear the lecture becomes higher, right? Similarly, if there is no compulsion, the chances of compliance with the order becomes higher, because if you didn't want to comply, you didn't have to sign it, right? I'm just going to take a pause here. I just probably will highlight the different modes of conciliatory dispute resolution. Conciliation, you might have heard from the Arbitration and Conciliation Act, Part 3, and mediation, word you might have seen in so many statutes, including the CPC of the compulsory courses. Then you might have heard of Lok Adalats. May, from your internships, visits to courts, would have heard about court attached mediation centers, may have known about community mediation centers in RWAs and Gurudwaras, in any of these community centers. And of course, there are private mediation institutions. These are the places, or these are the institutions, methods through which we will connect with mediation. Now, before I just go on to talk about the mediation bill, I mean, questions we can take later, but I just wanted to ensure that everybody's with me so far.
Yes, Sakshi, I think we have some participants who have been with us consistently and will remain so. So,
Okay.
yeah, please feel free to move on to the next section, or in case you want to move to a dialogue sort of a uh, mode, like it's up to you at
Okay.
your
So
discretion.
I think I will move on because we still have to talk about the mediation bill, and that still remains. I will also share the mediation bill with all of you so that you know what it looks like. I'll just take a minute.
Please go ahead without hesitation. We are listening to you intently.
Okay, this came late in 2021, the mediation bill. Why did it come? It came because there was no law around mediation. Mediation was being used very commonly, and there was law around conciliation. Now, what is the difference between mediation and conciliation, and is there really a difference? Now, till last year when I used to teach this course, there was a law governing conciliation, which is the Arbitration and the Conciliation Act, whereas there was no law governing mediation. Mediations were happening in India. Mediations was something that was encouraged by the CPC under Section 89. However, there was no law governing mediation in India. So that's why we had to distinguish between the two. And I think just for the sake of distinguishing them, we used to say that mediation is where the third party or the mediator is somebody who only listens actively to the parties, helps them resolve the dispute, but does not engage with them on matters of substantive law, which means that the mediator will never give a suggestion or will not evaluate the position of the parties, but only help them understand each other and find a resolution. Whereas in conciliation, which happens still today more in court attached situations, is where the parties talk about law, talk about a situation where they will go to court and what will happen there. Here you can see the style is evaluation. It's also known as early evaluation, which means that right now me and Bharatendu are sitting and talking, evaluating what will happen if we go to court tomorrow. He feels that he is going to win this case because ABC, and I feel that I'm going to win this case because of CDE or DEF. And the mediator will actually give an opinion as to whether ABC is correct or DEF is correct, and in the previous case, what had happened, and if there's a case law around it, basically there will be a discussion or an evaluation about the outcome of the case if it goes to court. And suppose I see that if we go to court I'm going to lose this case, so it will push me a little more to resolve this right here, right? So this was more conciliation, where the mediator actively, or the conciliator, the third party, actively evaluated the positions of the parties and gave them solutions. Whereas mediation would be more therapeutic, in the sense that you will be pushed to find a resolution by yourself. Nobody is going to say that on law point you're wrong, or if you go to court you will have to pay this much money, but you will be left on your own. Of course, the mediator will help you understand each other, because a lot of times when parties are angry with each other, they are not able to understand simple basic things. And this is not just for business or commercial disputes. You would experience this at home perhaps, that if you're angry in that moment, maybe with your parents, with your friends, with your siblings, even simple things you're unable to evaluate logically, whereas the next day when you sleep over it and you think about it, or if somebody else, say for example you've had a dispute with your mother, but your best friend explains it to you in in, in similar words, but you just hear it from a third party, and this party is not giving her opinion, it's just explaining where the other party comes from. A lot of times that helps you open your mind to a solution, because angry people don't want to compromise. But if somebody else explains the logic to you, and mediation worked on this principle, right? That if parties sit in front of each other and they want a resolution, uh, the problem they say, this is called the who will blink the eye first. And this happens again even at home in all disputes. Nobody wants to take the first step to compromise because you feel that there is weakness attached to it. Say, for example, if Bharatendu and I are in a dispute and I suggest that we should mediate, I would not want to do that because it will make me feel inferior, or I will think that this might give an impression that my case is weak, that if we go to court tomorrow, I might lose. And if Bharatendu wants to propose, maybe he also wants to propose mediation, but he will be reluctant to do it because of the same reasons. So, how does the law intervene and help us? The law says both of you don't have to feel weak. We will tell you, we will mandate it, we will make it compulsory for you to sit across the table with each other. And only if there is no possibility of you resolving it on your own will we let you come to court. So, not that courts are not going to be working anymore. Courts will very much resolve all our problems, but the court will want to give us a chance to resolve it on our own first. So this is what compulsory mediation is. The attempt to compulsory mediation is. This is what why we needed this bill. This is again repeating myself, but this is why the mediation movement was required, because we needed a law to intervene. There have been times when people have on good platforms with well-read lawyers spoken about mediation, and people have confused it with meditation, right? So a recourse, a discourse was, a dialogue was needed. And more than anything else, I think the mediation, the relevance of the mediation bill is because you and me today are sitting and talking about it. More and more lawyers, more and more law students, more and more stakeholders of disputes will be exposed, will speak about mediation, whether positively or negatively, but at least an alternative will stand in front of us. So this is your introduction to the mediation bill. I still haven't focused on how did we regulate mediation till today. So there was a shortcut to do this, which means that if me and Bharatendu actually resolved our dispute through mediation, which means Mr. Singhal, our mediator in our example, he mediated our dispute, which means he did not actively participate but helped us reach a solution. We would sign that document, which will be our settlement, me and Bharatendu. Now we can enforce it in two ways. This is a contract after all. All contracts are enforceable in India under the Indian Contract Act. So it becomes enforceable like that. Also, if we call it a conciliatory settlement agreement, remember conciliation was something, is still something which is regulated under Indian laws by the Arbitration and Conciliation Act. So if we call it a conciliation, then our settlement agreement by virtue of the Arbitration Conciliation Act becomes a an arbitral award, and an arbitral award in turn becomes a decree of the court. So indirectly we did say that all mediations in India, also whatever is agreement comes out of it, would ultimately become a decree of the court. But you can see how this is like a very manipulative way to call it a decree. And no, we wanted more dignity for mediated settlement agreements. Another impetus or push came with what Bharatendu highlighted in the beginning, with the Singapore Convention. When India signed, India was one of the biggest contingents to be represented in the Singapore Convention, and one of the first signatories. So when India promised as a signatory to the Singapore Convention that all international mediated settlement agreements will be enforced in India, will be valued in India, will be treated as a decree of a court in India. Then the question became, what about our domestic mediated settlement agreements, right? So that is why, again, the government, the legislature, and the executive had to come together and think about a law around mediation. That's how the mediation bill came about. The earlier draft that was shared uh, was, I would say, a little rudimentary compared to what has now been given to the Parliamentary Committee. This is still with the Parliamentary Committee, and very, very fortunately, I had the I had the opportunity to go to the Rajya Sabha. This was the Tuesday, 2 weeks before today exactly, and make a representation about what can be improved in the mediation bill. So I will now try to focus. I'll not go clause by clause with all of you, but focus on 5 to 6 most important um, terms, most important clauses of the mediation bill. Irrespective of what the mediation bill looks like today, this is definitely a step in the right direction because at least there is a law to govern mediation. Now, remember, I was telling you that before this, we had to talk about the difference between mediation and conciliation, which was cosmetic to a large extent. Now onwards, if the mediation bill comes in its present form into a law, becomes a law, all the differences between mediation and conciliation are now set to not be there, which means that part 3 of the Arbitration and Conciliation Act will be removed, and all conciliations or mediations in India will solely be governed by this mediation bill. A good thing or a positive thing here is all the confusion is gone. If there is a third neutral party helping you reach a decision without any compulsion, means it's between the two parties whether they want to sign on the settlement agreement or not, that will be called a mediation and will be governed by the Mediation Bill or the Mediation Act of India. So, one thing is all the differences are gone. Okay, I'll just see where we are. Need an urgency. Okay, another problem we were facing why the mediation bill is required, and again, I'll give you a oversimplified example that um, if you give somebody substandard whiskey and tell them this is good whiskey and you make them have it and they don't like it, eventually they think this is what whiskey is and it is terrible, right? This is something that was happening with mediations in India, right? We had no regulation about mediation, which also meant that there was no regulation as to who will be a mediator. Imagine if this was happening with judges or chartered accountants or company secretaries. No regulation on who can be a company secretary. What would happen, right? Anybody could become a company secretary. Would you believe this is the situation of mediators today in India? If I say I'm a mediator, I am attaching where I have done my mediation course from. But those institutions giving me that training and that certification, are they certified? Is that regulated? None of it is happening. As we speak today, there is no regulation on this. So the situation or the problem, the threat there is that untrained, low quality mediators will be doing these mediations, will conduct it as if they are arbitrators, will try to decide, will push the parties too much or will not push the parties too much, conduct bad or substandard mediations. Now, I told you we are at the brink of these times when we are creating awareness about mediation. At this time, if the quality of mediators is not good, people will think mediations are bad. A mediation is only as good as the mediator. So if the mediators are substandard, we will create a understanding or a belief in our country that mediations are useless. Because the mediators were useless, you start thinking, and then this will become a general idea. Now is the time to prevent that, and that's why the mediation bill is very relevant because it quality controls mediators. Now, I'll tell you the scheme in the act, in the bill, but this was a big lacuna in law which was required to be plugged in. And of course, enforcement. I told you there was a long cut towards enforcement. You could call it a conciliated agreement, etc. But that was not a very dignified way to treat mediated settlement agreements, and that's why the mediation bill was urgently required. What does the bill represent? A mediation movement in India, recognize status of mediated settlement agreements. So this bill, one of the things that it does is it says that if Bharatendu and I have a agreement which we came to enter after the mediation, that settlement will have the same status as that of a decree of court. So then, if the outcome is the same, why do we have to go through court and let somebody else decide who's right, who's wrong? When we can sit together and decide ourselves, and the outcome will have the same value in terms of enforcement as that of a decree. So that becomes now an apple to apple comparison. It does now provide regulation on the quality of mediators, and the last important part, which we'll discuss now, is compulsory mediation. Now, what is compulsory mediation? Is it ethical? One of the key features of mediation is voluntariness, which, like I told you, means that if Bharatendu and me are involved in a dispute, we will, and if we decide to mediate, nobody will tell us that we have to agree and get up. Means that twice we sit, we talk about it. One day he kept complaining, one day I kept complaining, and we did not reach a consensus. Then nobody will hold the door out for us, lock us in the room, or put a gun to us and say that you have to settle and get up. No, that is not compulsory mediation. Compulsory mediation means an attempt is compulsory. So what right now the present bill is doing is saying that if me and Bharatenu have a civil dispute, civil is what the law covers right now, we will have to twice sit across the table. If after that we do not want to settle the dispute, we always have the option to go to court. But at least two times we will have to sit across each other and discuss or attempt to resolve the dispute through mediations. Let nobody tell you that all disputes can be mediated. A lot of disputes cannot be mediated. The parties just don't want to settle. It is more than the dispute for them, right? In that case, what can mediation, or what can the best mediator in the world do? Nothing, right? You cannot force the parties to settle. What you can legally, statutorily ask them to do, which the mediation bill is doing, is to attempt mediation. Now, you may think, then what is the point? You just tick the box, try mediation for 2 sessions, and then get up, say it failed. Now, the proof is in the pie here, right? When you sit across the table, and this is what was seen in so many jurisdictions across the world, especially in impersonal smaller disputes. If it is purely a commercial dispute, if I bought something online and it turned out bad, I genuinely probably just want a replacement of that. This dispute is nothing more than that. Maybe I was inconvenienced and maybe some coupon I want for the harassment I went through, but generally it is not more than that, right? So in these cases, when the parties do sit across the table to each other and there is some offer on the table, more often than not, mediations turn out to be successful. This is what has been seen, tested in the West and the Far East. Singapore, uh, Hong Kong, all of these Southeast Asian countries, which are the hub of arbitration, also parallelly continued developing their mediation infrastructure, and it is seen as a proof that more than 50% disputes, commercial, I mean, of course, I can't say all disputes, but a certain category of disputes will get resolved if parties are made to compulsorily sit. So, yes, that is the trick, or that is the magic weapon that we have to use, make them sit across the table. Now, one more example I'll want to give all of you, and this is the example of the Italian model. Now, Italy, till about 20 years back, was very infamous for delay in dispute resolution. Just perhaps how India is today in the global eye. If you go to the court in Italy, probably for the next 10 years is you'll be stuck there, right? This is the kind of image the common man has, even in India. So there was an ingenious sort of a solution that came into being, and again I'm going to make Bharatendu my adversary for this particular example. Here he is demanding, or he has sent me a legal notice saying that because of the breach of contract, he needs rupees 10,000 from me, right? And now what Italy courts did was say that, okay, fine, this is just about money. If that is the only relief, it's about the amount on the check, then don't come to court first. First, you both sit, and the plaintiff, which is Bharatendu here, will have to give me an offer. Sorry, the defendant, will have to give him an offer. So maybe I say I will not give you a single penny. Maybe I tell him I'll give you 5,000, or maybe I agree to give him 10,000. Let's take the example of me agreeing to give him rupees 5,000. All right. Now, Bharatendu, the plaintiff here, will have two options. He can either take that offer of rupees 5,000, or he can leave that offer. Now, most times the plaintiff would overestimate his compensation or the money that he needs. So, if he feels that 5,000 is a fair estimate, for the damages that he had to face, he will accept the offer. Well and good, court was not bothered, our dispute has been resolved. Even though this was not a mediation, but an offer was made outside of court and it was taken, and so the dispute was adjudicated, resolved, whatever, it did not go to court. But what happens if Bharatendu refuses this offer? So remember, he's asking for rupees 10,000. My best offer to him is rupees 5,000. Now he declines that, which means both of us will now be constrained to go to court. In court, two things can happen. Bharatendu will either be given a relief for higher than 5,000, which means maybe whatever he said was absolutely correct and he could prove it. Maybe 10 years later, but he could prove that he deserved rupees 10,000. In that case, very good. He was offered rupees 5,000, but he did not take it and he got rupees 10,000 in full. Fine. But what if the other situation happened, which means that he was given, say, only rupees 3,000. It was adjudicated on basis of his claims that even though he was asking or praying for rupees 10,000, his compensation by law is only rupees 3,000. Remember, I offered him 10 years back, or initially, that I am ready to give him 5,000. He did not take that. And he dragged me to court. We both spent a lot of time in court, time and resources of the court. And in the end, it was seen that actually his claim was overestimated. Now, didn't he waste so much time of the court? Of course he did. How do we punish him? We say now that accordingly, pecuniarily, he will be punished. He will be asked to pay or make up for the extra 2,000 that he missed that I was ready to offer him. In this way, what Italy forced its plaintiffs and defendants to do, its disputants to do, is to have an offer based on settlement before they come to court, right? Now, not exactly this. I don't think in India we would take a stance this strong, at least right now. But the mediation bill talks about something similar, which means that now this is not in India, in our bill, it is not restricted to only commercial disputes, which means that if now in India, okay, please stay with me in my examples. Bharatendu and I are now in India, and he was supposed to come for mediation, and he did not come twice. If he doesn't come twice, the mediation is supposed to fail, because remember, twice it was compulsory to sit across the table. Now, if this goes to court, and later it was decided that actually Bharatendu was the person who committed the wrong, and he was the person who did not show up in court also, in mediation also, without any justifiable reason, then the court might impose costs on him. If he is somebody who avoided mediation and forced the other party to come to court, and it turns out that he is wasting the time of the court, then the court may impose costs on him. Now, this is a very diluted version of the Italian model, but understand the intention of the legislature and the executive here. It's a mild push to make the parties try mediation. That is what we are doing here as a policy. Yes, Bharati.
Sakshi, this is quite interesting. Like this Italian model which we have discussed with us, it is quite interesting, and it so happened that in yesterday's class we were covering this section where it was mentioned that a defaulting party who has premeditated and decided not to turn up in the mediation session would be subject to costs being imposed by the court. So one of the discussions which we had in class was, it looks like we understand what the intention is, but it seems it will be difficult to implement it. But when you give us this context as to this is something which has been borrowed from a jurisdiction where the mediation process is at a higher threshold, I believe that this can be one first step where eventually over the course of many years we can raise the bar to include those provisions, and having a provision where costs can be imposed in the basic or the first act of mediation can go a long way in the long run.
I agree, absolutely. So right now the costs are also absolutely discretionary on the courts. So it's just say a very a minor punishment for not showing up for mediation. That is what it is right now. But like you said, other jurisdictions which were where we are 10 years or 20 years back have tried it and it has worked successfully. And that is why I say that the proof is in the pie. Let us have good mediators conduct mediations, thousands, lakhs of mediations across India, and then see whether how much of a success rate there is. Now, here is where I go to the next part of quality mediators. Now, how is the mediation bill tackling with that problem? Just check whether definition of mediation, I've told you that now mediation also includes conciliation and everything will be regulated by this bill itself. Now, before we go to the problem or the question of how to regulate mediators, just a small note about what the mediation bill says can be mediated. As of today, the bill pending with the parliament talks about a schedule 1, in which there is a list of subject matters which cannot be mediated. Now, in my personal opinion, this is a problem because we have come to a stage where we don't talk about what can be mediated, but the question should be why can this not be mediated? Right? If the parties are agreeing, remember this is not really forced on somebody. So if the parties want to mediate it, why should the law put it in a schedule, put it in a box, blacklist it, and says that no, mediation should never be even attempted for these subjects? And some of these subjects are very, very, I mean, we've seen mediations happen around it. Say, for example, a lawyer with the BCI or MCI, Medical Council of India, versus a participant or, sorry, a member of such a professional body. And the list says that you cannot mediate these disputes. Now, these are problematic. Tax matters are in the list which cannot be mediated. Now, the government, the tax department itself has been, even if you read newspapers, they want people to mediate their disputes with the department. So this seems to be, the schedule 1 seems to be not in compliance with the overall purpose of making mediation more accessible and increase the bandwidth of what can be mediated. One more problem I'll highlight here, and this is again a controversial point. A lot of people say that criminal matters should never be mediated. Now, when I say criminal matters, I'm talking all compoundable, non-compoundable offenses. Problem here becomes in India, and I don't know whether this is the case in other places, but say if there is a purely matrimonial dispute, there will be elements of criminality in it because you can include 498A, invariably that will happen. Now, if you just blacklist and say that any matter which has a criminal element in it cannot be mediated, then where will all these, numerous matrimonial cases go, which are ripe for mediation, which are ready for mediation, which have the highest success rate? Matrimonial and family matters have one of the highest chances of being successfully mediated. But if, and this happens on purpose, the criminal element is brought in to gain powers, to gain bargaining powers, and most often that is the case. I'm not saying always that's the case anymore. But if you say that just because the presence of a criminal element, if this cannot be mediated, then we are shutting a lot of potentially mediatable disputes from being attempted to be mediated. Another example I want to highlight is probate cases or any document if is in question. Say, for example, there's a will, and me and Bharatendu are fighting about what we are getting from that will. One of us will definitely allege that bill is concocted, that will is false, so it becomes forgery. There is an element of criminality now. Most of these cases can be mediated, but just because a criminal element has been brought in, now as per this bill, these disputes will never be allowed to be mediated. So this is problem 1 that I want to flag. The schedule needs to be reconsidered, just so that more and more disputes can be attempted to be mediated. Now, of course, some disputes the court will have to step in and say, sorry, this cannot be mediated. And that is what happens in arbitration also today. As you know, there is no list that says these cannot be arbitrated because even subject matters are developing, right? So, what could not be arbitrated yesterday is arbitrated today. Similarly, for mediation, what and I would love to hear from the students what they think is that the list of what can be mediated, cannot be, should be left fluid. Moving on, okay, another problem two that I want to highlight or flag is section 2 of the bill itself says that if government is a party to any dispute, then such disputes compulsory mediation would not apply, which means that if instead of Bharatendu versus Sakshi, it's Bharatendu versus state of Madhya Pradesh, PWD departments, and you must know that state is the largest litigant in India. In fact, when me and Bharatenu were working at the Law Commission, we were talking about the national litigation policy and how important it is to have early evaluation, mediations, conciliations, everything for the national litigation policy. So keeping government contracts out of the mediation bill is deflating half purpose of it. All that will still clog the courts. So that is another problem, or something that has to be seen. Now I will just tell you about MCI, MSP, and MI, three acronyms which will then determine how mediations will be conducted in India. There will be a Mediation Council of India, which will be like the Bar Council of India or the Medical Council of India, which will be the regulatory body at the top of mediators, mediation institutions, etc. And that is going to have representation from the government and from experienced mediators. This body is going to be a body in itself that will regulate these two other bodies. Which are these two other bodies? The mediation institutions and the mediation service providers. The mediation institutions will be something like a university, but for mediators. So, example, there are 10 universities that can certify or accredit mediators, right? And these 10 will have to be certified by this Medical Council of India. Just how the UGC would conduct and check whether this college is doing the LLB program well or not, and then certify them. Similarly, this Mediators Council of India will check these mediation institutions to see whether they are providing quality training or not, accreditation or not. So this becomes the mediation institutes, almost a tongue twister now. The third part is the mediation service provider, which will be the counterpart for arbitral institutions. Now, this is where the consumer will come in face with the mediators. Now, mediation institutions are providing good quality mediators. How will these good quality mediators meet common man? Good quality mediators will be listed with the mediation service providers. Say, for example, in Delhi, there is this body called Madhyam, there's this body called CAMP in Bangalore, etc. They would on their list have mediators who have been accredited by the mediation institutions. Mediation service providers will provide you mediators, will provide you a room, will provide you rules, etc., for the mediation to be conducted, just like arbitration centers. This will be the job of the mediation service providers. Now, I will also break down mediations into different kinds. Three to be general: private mediations, court attached mediations, and two more now: online mediations and community mediations, which the bill talks about. What is private mediation and what is court attached mediation? Now, court attached mediation center is relevant right now, is where mediations are happening right now. Remember, section 89 of CPC says that if a case is fit for mediation conciliation, send them to mediation conciliation. Now, where do judges send these cases to? They send it to court attached mediation centers. To give you the example of Delhi High Court has a court attached mediation center called Samadhan. So all the cases which are referred by judges to mediation are sent to this body. There are mediators there who are trained by the Delhi High Court. They conduct these mediations. You can check out the website for Samadhan, and similarly for Bombay, Bangalore, Ahmedabad, Chandigarh. These are few mediation centers that I have visited myself, and I can tell you they do excellent work. You can check what their status is. The Policy for Legal Research has also published a paper. Bharatendu, I think, can share it with the class later on the success rate of these four court-attached mediation centers that I spoke about. So, what kind of work are they doing? Family matters, what kind of matters? What is the success rate for this? And they are all doing very well. This is with regard to court attached mediation centers, and I told you their mediators are trained by the respective court, and rules and regulations are framed for such courts by the High Court. for such mediation centers by the High Court. This is functioning right now as it is. Not much is going to change in terms of setup here, except that court attached mediation centers will also be listed as mediation service providers under this bill. What the impetus this bill will give is to private mediations in India, which means that now, suppose me and Bharatendu really believe in the potential of mediations in India, we both decide to make or create a mediation service provider. We call it MSP services. And now, how will we run this will be regulated by the bill and the regulations of the Mediation Council of India. This till now was not available at all, which means even if we wanted to start a mediation service provider place, we did not have any legal backing to show our credibility, which is something we will get now by the mediation bill. There is one example that I always give about a private mediation center which has been there a long time. It's called CAP. It's in Bangalore. Um, they are very active in policy as well as you can see their website as well. Private mediation. The bill talks about one other kind of mediation. One is e-mediation, online mediation. Now, especially after pandemic, there was a surge in people wanting to mediate online, means that if a single person in interviewer is in Guwahati and Delhi, and I think was dating, three of us even mediate online. Those are about it. In India, has been asked to make regulation about mediation, but does get statutorily back. The other mediation, unity mediation required very much area, which means, and this is for you almost access to justice. It's where the person who does not have the legal active or backing lawyers who would be mediation. And will be some very relevant where people fight about backing. There are murders that happen about civil disputes because there is so much rage. So the mindset of rage or the mindset of proving somebody else is wrong has been stimulated at the community level with the resolution mindset. Change is not to have happened every day, but if we have community mediation centers, community places like Gurdwara, Ardaway, so that will allow you to aware that you have these are the places you can resolve. One example of this I tell you is the TDR, the Legislative Resolution Center. Again, check that right. Just Varma is in that center right now. He does some basic work. There are about 20 centers running Delhi right now. If already there, then if over there, and that is the theme of unity mediation. And not just via mediation, much like that, but also for community related issues. One change that I would suggest is that we said Gaza's pre-mediators, community mediators. It's again like an adversarial system because nobody is really deciding why do I need an odd number. So that is very selective of somebody so that can change to more because again now one of the recent examples is that I had a dispute over mediation and facilitated dispute negotiation and these are the examples of community mediation that another parties are involved. And that case may require more than mediators. So that will be another problem with community mediation is that the settlement agreement system will break now on it. Basically, we have to lag and just quickly if there's anything else, but it is possible that you this mediators have discussed as last part with back to Bharatendu is about fixing or mediation. So yes, we decided and we say that we will comply, we will enforce all international mediation settlement agreements in India. But as we talk about it, it is very precise. And the earlier bill was talking about it, what has been mediated now for the Rajya Sabha does not even mention this word. So are we expecting another law or can likely arbitration have another large talk about international mediation? Again, very relevant. Give an example, a lot of family disputes which happen in international custody issues, compulsory issues, or any so much on it. So that is relevant. Is this a mistake that has not been included? Development chapter can be added, or that is another suggestion you made. As you know, and I hope there's still some questions that everybody will encourage to read it. The time for giving your expectations now unfortunately closed. But 2023 format of beginning about this tomorrow we will be using the mediation, right? And so over to you, Bharatendu.
Thank you, Sakshi. Thank you so much for sharing your insight and going into quite a lot of detail. And there are a few things which I do pick up from you, and I think they do require highlight here. I think one of the important things when as teachers I used to face was try to explain to students the difference between mediation and conciliation. The line was so thin that it was difficult to capture the mind of young students when they are not familiar with the ADR process at all. So how do you draw a fine line? And there were so many questions that even I used to get confused often. So one thing that I think everybody would agree, academicians and practitioners alike, is this approach of merging conciliation into mediation and eliminating that difference is definitely a big step forward. And irrespective of all the flaws, which gaps, I would say, not flaws, gaps it has, there's always scope for improvement, and it is the right step because, as you used the word dignity to mediated settlement agreements, dignity in the sense that when you have a document which does not have the same legal standing as compared to a judgment of the court, it inherently creates a gap for participants to opt for that because you've already put it on the back foot. And then in addition to that, the lack of regulation, where you have described quite vividly why the ADR process of mediation was getting a bad name. Because it is an unregulated area where people who are not qualified are sort of conducting the mediations in any manner they please. And all the people who are actually participating in the mediation are getting this idea that what is this? This process seems like a sham. And when this sort of bad publicity starts happening about something, it is difficult for it to take off. And we have to understand that while arbitration is also an ADR method, in today's time it has become extremely adjudicatory in its nature. It is not actually aligning to the original goals of ADR. And I believe with this mediation bill, there is certainly scope for us to come back to the basics of why the whole concept of alternative dispute resolution was commenced in the first place. And you in the beginning very easily explained this concept of compulsory mediation, where the idea is not that you have to compulsorily mediate, but the idea is that you have to compulsorily make an effort to mediate. I think you put it in a very crisp form. I think one more point which I do pick up, and I would certainly quote it in my classes in future, is India is making significant efforts to be an hub of arbitration. But if you look at those jurisdictions which today are doing really good in arbitration, especially Hong Kong and Singapore for that matter, they have made significant efforts to parallelly develop a mediation infrastructure. And I think with this bill, because the impetus, there's a lot of impetus of the government for ease of business and promoting India as an arbitration hub. I think the fact that more emphasis on mediation would also help that original effort of making India a hub of dispute resolution, I would say. Rather than saying an arbitration hub or a mediation hub, I would say a hub for resolving disputes. With that, I think we had one question in the chat box, but I think that is already covered. It talks about compulsory mediation. We have covered that. So in case anybody else has a question, they may raise their hands, or if anybody has a question, they may type it also. I believe we may not have that many questions. Let me see, I have noted some notes down. Is there anything which I wanted to ask you? I think we've already discussed the cost aspect where you gave us the example of the Italian model. Right. Anything else which you would want to make like a closing remark on, Sakshi?
I just probably answered to looking at saying yes, if we have the current bill into an act, and there will be a compulsion mediator for every civil dispute, I may add, and tort and then contract both are some specific. So yes, there will compulsory attempt and mediation. They try that not really allowed.
Right. If no one has a question, Sakshi, we are talking about the formation of the mediation council. One of the criticisms which had come about in the initial phases was that this seems like a government body. Now, why this criticism is there? Because you have a chairperson who's going to be nominated by the central government.
So now that's changing. Sorry. That was part with the bill that now goes to the Rajya Sabha. The chairman and 3 members were now any person, including one accreditation.
Right. So that means like we have one chairperson.
Right.
We have one practitioner expert of mediation, we have one academician expert, and then there are 3 ex officio members
Government.
and we have a CEO. So does this sound like okay? I believe that you're saying that there have been some amendments here, so maybe we should not go into this because
I now like another law commission.
Right.
But now it's just like they're experts of the field, which is what's required.
And there are several provisions where the act says that these provisions will be notified further. So I think the goal with this bill is to lay down a framework and then empower the mediation council to bring about more rules and regulations as time goes forth.
So a lot will actually depend on the functioning of mediation.
Right. Thank you, Sakshi. Thank you so much for your insight. I know it's been challenging for you to take time out for us with so many things on the personal and professional front. I, at the School of Law, express my gratitude to you, and I would invite Professor Bose to give a formal vote of thanks.
Thank you for giving me this privilege, Mr. Bharatendu. You have covered everything in your closing remarks. And you have extended thanks. Nevertheless, I am still that this is very insight into this mediation bill. Lot of things very simple, explained, which I like. And most important, what I like was the power of illustrations and their data analysis. You was giving an example of what the process. And sometimes you have something like one working on the big picture. So, but it was very nice and very simple. I explained a lot of things. I'm sure most of the students have been highlighted very interested. Personally, I get great learning for me. And on behalf of the School of Law, Manav University, and on my own behalf, I extend my thanks for sharing and giving you all the time and listening to the mediation. Thank you so much.
Thank you so much for giving the lecture.
Thank you all participants. Thank you Varsha ma'am for the opening remarks. Thank you Dr. Bose for the closing remarks. Thank you Sakshi for such a wonderful session, and thank you all the students for participating. Thank you so much. Have a good day.
Thank you.